Welcome and thank you for joining the first webinar in the series on advanced bail advocacy. Today's topic is how to cross-examine the officer in charge. My name is Karen Brown and I'm a Learning and Development Specialist at LAO. Your facilitators today are Stephanie Haynes, Senior Counsel in Newmarket, and Dina Zalkind, Criminal Duty Counsel at 1000 Finch in Toronto. Let's get started.
Good afternoon, everyone, and thank you for joining us. Before we begin, we wanted to say that although in the past, Duty Counsel may not have done many bail hearings with officers being called to testify, with the recent changes to legal aid, we may be seeing more of these hearings, and we may be seeing more officers coming to testify at our bail hearings. And although it's something that may be unfamiliar, it's not a bad thing because officers can be valuable sources of information to the defense. So, of course, as you know, at bail, the evidence that's introduced has to be credible and trustworthy. It's governed by Section 518 of the Criminal Code. And in order for the Crown to be able to read in the synopsis and rely on the synopsis at bail, the defense has to agree to that. If the defense does not agree, then the Crown cannot simply rely on the synopsis, and the Crown will have to call evidence, will have to call an officer to testify. And often the officer will have information that's valuable to the defense, and you can ask the officer questions about weaknesses in the Crown's case, weaknesses in the investigation, and ultimately use those weaknesses in your submissions for your client's release and relate that to submissions on primary, secondary, and tertiary grounds. And essentially, the point of this presentation is don't be scared of the officer in charge. The officer will often be valuable to the defense as well, and we will give you some tips and some tools to use in getting as much valuable information for the defense from the officer in charge in this presentation.
And one thing to keep in mind as well when you're talking to the officer and trying to get some information from the officer before the hearing, officers are often very friendly and willing to share information with you, but don't let your guard down because sometimes what they're trying to get is information from you about your client. So be mindful in your discussions with the officer. You want to get as much information from them, but generally you don't want to disclose anything inadvertently from your discussions with the client or any potential sureties that can then be used against them. So remember that there's no property in the witness. You can talk to the officer, and when you talk to the officer ahead of time, you want to find out as much as you can about the investigation, and those will be things that you think about when you read the synopsis. So if you have questions about where evidence was found, if you have questions about what ties your client to the allegations, those are the kinds of things that you will be thinking about. And you will also want to ask the Crown for some disclosure of whatever evidence they will be relying on or whatever evidence is available for you to prepare for your cross. And those might be things like officer notes, there might be some videos, some surveillance videos, there might be photos. So get as much information as you can to prepare for the cross. And talk to your client ahead of time as well. Sometimes we forget, we focus on the disclosure, and we forget that our clients might be valuable sources of information. The client might have information that's very important for you to know before asking the officer any questions. So the client might tell you about things that were not located or things about the residence that are important for you to know. So those are all things you want to keep in mind. In terms of the disclosure that you get, very often the disclosure will be limited at the bail hearing, so you will have time the morning of to review whatever information you can get. But there are times when disclosure will be more substantial or voluminous, and at that point you will need to get your client's instructions about taking some time to review that before the bail hearing, which may require an adjournment of a day or two. So those are things to keep in mind when you do get disclosure. But you do want to get as much information as possible. That's your ammunition, essentially, to attack the Crown's case, to attack any weaknesses in the Crown's case, to raise potential defenses based on not your client's testimony, of course, at this point, but based on the information that's available from the investigation itself.
So when I prepare for a cross-examination of an officer, I'm pretty systematized. So what I recommend is the first thing you do is that you write down the facts that you want to elicit from your officer witness, and of course you get those from the disclosure or from your client. Then you write out what you hope are going to be your closing submissions focusing on the primary, secondary, and tertiary grounds. You literally write out your quotes. And then you draft your cross so that you elicit those facts and limit yourself to eliciting facts that you know are already admitted in the documents before you. And when you're doing that, when you're preparing for your cross, just like Stephanie said, what you want to think about is the goals of the cross-examination. So you want to start by thinking, what submissions do I ultimately want to make at the bail hearing? And those, of course, would be about the primary, secondary, and tertiary grounds. But you essentially start at the end, and you think, if I want to make this submission at the end, what evidence do I need to get from the officer to get me there? And so these are the points that you make in planning your cross-examination, and these are the questions that you'll be asking the officer. And we'll go to the form of cross-examination and the form of the questions. The questions, of course, will be leading questions, and so the points are really your questions. You're putting statements to the officer, and that's the information you're trying to get the officer to agree to, and that's the evidence that you'll be using in your final submissions. So you want to think about the questions, and the questions will be tied to the issues in the Crown's case. They'll be tied to weaknesses in the Crown's case. So you want to ask about any ID issues. Is there any evidence tying your client to these allegations? Is there any, for example, with charges with drug charges or with weapons charges? Are there issues with knowledge and control? With the case that we have, with the simulation, with Mr. Donnelly's case, for example, is there anything tying Mr. Donnelly to the gun? Where was the gun found? All these are things that you'll be thinking about as you read the allegations, and those are the things you focus on in preparing your questions for the cross. You want to think about issues with credibility. You want to think about potential defenses. Is there any evidence that the officer can testify to show that there were self-defense issues? Are there any charter issues? So are there issues with the search? Are there issues with voluntariness, perhaps? And of course, it's not a trial. You will not be asking the justice or the judge to weigh that evidence in determining the ultimate issue of guilt or innocence, but those are tied to the strength of the case, and those are tied to your submissions at the end about release. The other thing that you'll often get, and something that you want to get from the officer, is I don't know answers. And those are usually good, because if the officer doesn't know something, those are issues with the investigation. So if you ask the officer, well, did you find any identification, for example, to tie my client to this drug that was found? Did you find anything else? And the officer keeps saying, no, I don't know. I don't know if this was done. I don't know if anyone else looked. Those are all issues in the Crown's case, and those are all weaknesses that you want to elicit at the bail stage. The other thing we wanted to mention in terms of preparing is what you may know from Crown's cross-examining sureties is Crowns would often ask questions about, well, what did the accused tell you about these charges? And or sometimes Crowns would even ask if a surety testifies to identify your client on a video. So Crowns use the bail hearing often for their own purposes, and you can do the same with the officer in charge. If there are charter issues, you can bring that out in your cross-examination, and of course you're not asking for the justice of the peace or the judge hearing the bail hearing to make any decisions on the charter issues, but you certainly will be referring to those issues in terms of tribal issues in your submissions on release. Try to. So the order of examination, as you know, first the party calling the witness will examine the witness in chief, and so the Crown will examine the officer in charge. One thing to keep in mind when they do that is that
you really should watch the form of the questions that the Crown is putting to the witness. You need to watch for any leading questions and do not allow the Crown to lead in their examination unless it's on really uncontentious issues. So the only thing that really the Crown should be leading on is, well, you're a police officer with the Toronto Police Service, for example. That's fine. We don't care about that. That's not contentious. But if the Crown starts leading on anything in relation to the allegations, stop, object. They're only allowed to ask open-ended questions, and the cross is where you ask the leading questions. That's not for the Crown to do. And we'll talk more about the form of questions and some of the objections later on as well. Then, of course, after the Crown is done, it's your turn to cross-examine, and when the Crown stands up to re-examine, if they do, that scope is very, very limited. So again, watch for what they're asking. They can only ask questions in relation to things that arose during your cross. If the Crown starts asking questions about other things that were not in evidence before, that did not arise as a result of your cross, object to that as well, because you don't have the opportunity to cross-examine on that information after.
That's right. If Crown attorneys stand up in reply and start asking questions that were never put to the witness, then you will never have an opportunity to cross on that new information, and that is referred to as splitting the Crown's case. And it's an egregious abuse. They're not allowed to do that. In addition, if they start re-asking questions that they already asked in direct and that you really didn't touch in cross, they're just reiterating, they're corroborating, trying to create emphasis. Don't allow them to do that.
And when you're cross-examining, you want to make sure that the questions you ask are things that you generally know the answer to. So feel free to ask the officer general questions before the bail hearing starts, sort of poke and get some, use it as a discovery, so to speak, before the bail hearing starts. But at the bail hearing, you want to stick to questions that you know the answer to. And the scope of cross-examination generally is very broad. All you need for cross-examination is a good faith basis for asking the question. So you can ask really anything you want as long as as you have some basis for it, but make sure that when you're planning it, the questions you are going to ask are things that you expect to know the answer to. One thing that we also wanted to mention before we go into the specifics of the cross is that cross-examining officers at the bail hearing is different from cross-examining witnesses generally and officers as well at trials. So when you think about trials for domestics or for impaired, for example, a lot of the time you would want to raise the credibility of the officer as an issue. If it's, for example, an impaired trial, you will probably have a lot of questions about the officer, about their observations, about whether or not the person was actually or appeared impaired, whether they had they were slurring their speech and all that stuff, even if that's in the officer's notes. So credibility might be an issue then. At the bail hearing, though, you're not challenging the officer's credibility. What you want to do is get as much helpful evidence for your submissions at the end as possible, and that's mostly weaknesses in the Crown's case. So you're not saying, officer, you're a liar. You're not going to get anywhere with that, really, certainly not with justices of the peace, generally speaking, at the bail hearing. You want to be respectful. You want to be polite to the officer, and you don't want to suggest that they're misleading. What you want to say and what you want to elicit is that there are problems in the case. And you don't ask the officer to agree with you that there are problems in the case. You don't ask the officer to agree with that ultimate conclusion. You save that for your submissions, but the evidence you're getting should point to problems in the Crown's case. And so what you want to get is helpful evidence and not focus on the evidence that's unhelpful to you. You're trying to really structure your questions so that you're getting as much helpful stuff as you can from the officer. And your examination, your cross-examination doesn't have to be lengthy. Your cross-examination can be very brief. If there are only a couple of points you want to get from that cross-examination, that's perfectly fine. You can always just ask a couple of questions and sit down if you're getting what you need. Sometimes we feel like, and I know I feel like that too, if the Crown spent 20 minutes in examination in chief and covered a lot of ground, sometimes you have the tendency to think, well, I need to I need to cover all those points as well, but you don't need to do that at the bail hearing. There are very specific things you may need to get, and if you get them, just stop and sit down. It may actually be harmful if you continue, because you'll be allowing the officer to repeat evidence that's harmful to you in your submissions, and you might be boring or annoying the judge or justice of the peace as well, so you don't want to do that. And of course, with anything you do, always, we'll keep coming back to that. Always keep your goals in mind. Whenever you're asking questions, think, is this going to help me on primary, secondary, or tertiary grounds? What am I doing that for? And if you don't see a point in the question you're about to ask, don't ask it. So we've sort of gone through that. We're not challenging credibility. We're looking for weaknesses in the Crown's case. And keep your audience in mind. The officers are, as Stephanie said, officers are professional witnesses. They appear very serious to justices of the peace. Usually the justices of the peace tend to defer a lot to the evidence of the officer. So you want to, the tone of your questions and the kinds of questions you ask and how you ask them, you want to ask them in such a way as to show to the justice of the peace that you understand this officer is a professional and they have something valuable to say, and in fact that they're on they agree with you on these things that you're asking. They agree with you on the weaknesses without specifically asking for the officer's opinion. We don't want to do that. So we've pretty much covered that as well. We're not at trial, and often when the other party calls their witness, we feel like we need to destroy that witness somehow. That's not what we do with the officer in charge. We're trying to use their evidence to our advantage. So now the form of the questions. We talked a little bit about that. The questions should be leading. So leading questions are basically statements. They're questions that contain their own answers. That's how you ask your questions. Remember, whenever you're asking questions, to go back to remember that they have to be leading questions. I know I have the tendency, and a lot of us do, to start with leading questions because you realize your questions have to be leading, but then as you get into the groove of cross-examination, you slide into open-ended questions because that's how we tend to speak. So just keep bringing yourself back to leading questions if you start sliding into open-ended questions. Open-ended questions are not helpful to you because they give the officer an opportunity to elaborate on other evidence that they gave in chief and sort of open the door. You want to be able to control your witness. You want to get a lot of yes or no answers to statements that you're putting to the officer in charge, so that you're the one in control. And you don't need to give long introductions to your questions. So you don't need to say to the officer, well, officer, in this case, Officer Stander, I'm going to now take you back to the residence and the time that you did this. You don't need to introduce those questions. Keep the witness on their toes a little bit and just put the statements to them. You don't need the introduction. You might have that introduction in your own questions to remind you what area of cross-examination and what part of the chronology you're in, but you don't need to introduce that to the witness. So some more on the form of questions, the leading questions. They need to be short, single fact questions, short statements. Use simple language. Don't, the example we have here is no one really exits a vehicle. So keep them very simple. Use looping when you can. So that means just build one question onto the next question. So if you say you saw a car, officer, it was a green car. The green car was driving west, and so on and so forth. So just build the questions one on the other. And don't argue with the witness. That's never helpful. You ultimately, if you're getting nowhere with a question, just leave it and don't try to convince the officer to agree with your conclusion. It's generally not going to help, and you're just going to get into an argument with the witness. Avoid unnecessary words in your questions, and I think we all do that, and I know I do that a lot, is either start all my questions with and. You did this, and you did this, and you did this, and you did that. So try to avoid doing this, but also things like, you received notice, didn't you? Or you will agree with me that? Or is this correct? Is it true that? So these aren't necessary. Just put the actual statement. You received notice. You went to the townhouse. You obtain a warrant. Whatever the case may be, just put the actual statement. You don't need to use additional language for that. All right, so some of the strategies. We talked about getting yes or no answers. Show the witness that you're in control of the information that you have in the case at this point. Show them that you know the case as well as you can, given the limited information at the bail hearing. And if the officer says something that's completely new to you, you can ask about, well, where is that? Have you disclosed this? Have you disclosed this to the Crown? And then you may, if they have and you haven't received that information, you may want to take some time to review that. So ask to make it clear to the Justice of the Peace or the judge that you don't have that information, and take some time to review that. Okay, so in terms of the order of your questions, again, we'll repeat this throughout. Keep going back to why am I asking this, and tying it to your ultimate submissions on release on primary, secondary, and tertiary grounds. Stephanie and I have a bit of a disagreement on this, but there are theories about cross-examining that say that your examination should be non-linear, so don't go through the events chronologically. Jump from one area to another so that the witness is on their toes a little bit, so they don't get too comfortable with just going through their notes, and they have to answer in an order that they don't necessarily expect. And I know, Stephanie, you have a slightly different view on that.
Sometimes. Certainly it is an excellent strategy at the trial stage. At the bail hearing stage, show cause stage, often the quantity of questions that you're asking isn't enough to sort of really be able to do that effectively, in my opinion. If you're able to do the jumping around technique and with the material you've got and still have comprehension clear to your audience, then absolutely. I just find that at the bail hearing stage it's often difficult and sometimes unnecessary.
So I guess depends on your case. You make that decision, but certainly be strategic about the order of your questions, and we'll talk about that a little bit as well. But you want to think carefully about what you start with, because people tend to remember what the beginning of the evidence is and what the end of the evidence is best. So try to start with a strong point and end with a strong point. And if you can't really start with a strong point, at least end with a strong point. You want the last part of the evidence, the thing that stands out in the justice or judge's mind the best. You want that evidence to be something that's helpful to you. So if nothing else, end with a very strong point and save your best for last.
And that I agree upon 100%. Absolutely imperative if you can possibly do it.
And then when you're doing the cross-examination as well, sometimes we want to introduce questions, but don't repeat evidence that's harmful to you. Sometimes it will be inevitable because you're introducing evidence or you're asking about evidence that the witness gave in chief in order to get evidence that's contradictory or minimize the weight of that evidence. So sometimes you will have to repeat certain harmful things, but stay away from it as much as possible. And again, when you get what you need, just sit down. And that's a very fine line sometimes. I know I tend to cross that line on occasion and go too far. But when you have the evidence you need and you don't think you could get any better than that, don't ask any more questions. So we've just talked about that, just what you start and end with. Beginning and the end is what people remember best. And if you can't start strong, at least end strong. Some things to not do. We've covered a lot of them already. Don't ask the one question too many. Don't try to get the officer to agree with your ultimate conclusion. Save all these things for your submissions. Just get the evidence that you need to be able to make the submission. That's all you're after in asking the questions. We talked about a lot of this already. Don't repeat the harmful evidence. And in your objections, we'll talk about some common objections next, but one of the main objections when, other than to leading questions by the Crown, when officers testify, a lot of them tend to give opinion evidence about issues that really are not for them to give evidence on. Lay opinion evidence is fine when it comes to certain observations like impairment. If the person, did the person seem intoxicated to you, officer? Did the person these are things, intoxication is something that people generally have in their common experience. So those are things that officers can give opinions on, but what they cannot give opinions on are issues that are ultimately for the judge or justice to decide, and that's things like, should the client be released? Is the client dangerous? Are there any concerns for, should the court have concerns for the safety of the complainant? How strong is the Crown's case? What's the significance of the circumstantial evidence? Are other witnesses believable? Is the complainant believable? That's not for the officer to decide. So if the officer is starting to give evidence, opinion evidence about these things that are not for them to decide, certainly object to that. And then some other objections, and you'll have the list here, but just some of the common ones. If the question that the Crown is asking assumes a fact that was not in evidence, object. And sometimes Crowns try to sneak evidence in by asking those kinds of questions. So be very mindful of that. Listen very carefully to the questions being asked. Opinion evidence, we talked about that. Questions that are too complex, you don't know, or compound, you don't know what the witness is what part of the question the witness is answering. So you can object and say, well, can my friend rephrase the question? It's a compound question. It's unclear what part of that question the witness is answering. Questions that are leading on disputed matters, we've talked about that. Questions that are vague. Any other objections?
Listen to the questions your Crown Attorney is asking in direct. I find that it's common to sort of be working on your cross and half listening. It's important. It's important to put your attention to the questions the Crown's asking so that these sorts of things don't get stuck in.
And then the next slide, this is something that you will rarely do at the bail stage in introducing exhibits through the witnesses, but on occasion, there is a helpful piece of evidence, such as a map, for example, that you want to introduce, and you can do that through the officer in charge. So I'll give you an example. There was a hearing not that long ago at 1000 Finch, and I had spoken to the family, and the allegations involved a young man being charged with gun-related offenses. And the allegations were that he was present at the scene of a shooting at the time. And I spoke to him, I spoke to his family. The Crown didn't really know where the shooting had taken place and when and where the client was arrested. So I had a map where it was clear that the client was nowhere near the scene of the shooting. And I didn't end up doing that hearing, but had I done the hearing, I could have introduced that map through the officer because he could identify the different areas of that residence. And so it's very limited, the circumstances where you would be introducing exhibits through the witness. But if there is a helpful piece of evidence, a map or a photo or something like that, that will assist in weaknesses in the Crown's case, then you can introduce it through the officer in charge and you don't have to call your own witness to do that. So we've covered this really as re-examination, very limited in scope. Just be mindful and just like Stephanie was saying, listen to the question and listen to the answer. If the question is about something that was not covered in or did not come out during cross-examination, then certainly object to that. All right, so we'll move on to our demonstration. Stephanie will be officer standard. And hopefully you guys know the scenario at this point. And one thing we wanted to just mention before we start is In our cross-examination, we assumed that after reading the synopsis and after speaking with Mr. Donnelly, you had gone and spoken to the officer in charge and you have some additional information. So you wouldn't have that information. You'll hear it from the cross-examination, but essentially it's information that the officer provided about the search, about the statement made by the complainant on October 11th, and about other recent input from the complainant on October the 12th. And we are now back on October the 14th. Today is October 14th, and Officer Standard testified in chief already, and now Officer Standard will be cross-examined. So Officer Standard, good afternoon.
Good afternoon.
Officer Standard, you testified in direct that on October 11th you spoke to Ms. Jones across the street from the Grumpy Judge Bar.
I did.
And that she told you that Mr. Donnelly reached inside her jacket and pointed an object at her.
Yes, I spoke to her outside the Tim Hortons, and she told me that her ex-husband, her ex-boyfriend, wasn't allowed contact and that he had pointed a firearm, a gun at her in the bar.
She said she believed the object was a gun.
She did.
Now, she made a sworn audio tape statement at the division that same night on October 11th.
Yes, she did.
You didn't take that statement yourself, but you're aware of the contents of the statement?
No, I did not take her statement. I was at the scene. She was taken to the police station and provided an videotape statement, I believe, which I reviewed the monitor notes, so very perfunctorily.
And you have those notes with you today?
I do, thank you.
Subject to her worship, feel free to refer to those notes, Officer Standard.
Thank you.
Now, in her sworn statement, Ms. Jones never said that she saw a gun.
She said that she believed she saw what she believed to be a gun.
She told police in her statement, in her sworn statement on October 11th, that she saw an outline of what she believed was a gun.
That's true.
So she never said that she saw a gun.
That's true.
She didn't describe a gun?
No.
She didn't describe any gun's color?
No, not in this, no.
Gun size?
No.
Gun's make?
No, that wasn't provided.
Now, your notes on this matter begin at 21:30 on October 11th?
Oh, one moment, if I could refer to my notes. Yes, that's correct.
That's 9:30 p.m.?
Yes, that's right.
That's when you received the call from dispatch?
It is.
And you attended the location around 9:35 p.m.?
Right, yes.
You met with Ms. Jones?
Yes, she was outside crying. She was at the Tim Hortons across the road. It was, yes.
And the Tim Hortons you refer to is across the street from the Grumpy Judge Bar?
It is.
The entrance to the bar is clearly visible from there, from the Tim Hortons?
It is. I wasn't staring at it, but you can see it clearly from where I spoke to her.
When you attended, you didn't see Mr. Donnelly with Ms. Jones?
No.
And at 9:40 p.m. you go into the bar?
That's correct.
That's because Ms. Jones told you she believed Mr. Donnelly was still at the bar?
That's correct. By 9:40, I had done computer checks to confirm the information that Ms. Jones gave me, that he was on a bail, that he had a condition to have no contact, and she had provided a description of him, and I received a photo, from the computer system of what he looked like.
So at that point, you knew what he looked like?
That's right.
Mm-hmm. And you went into the bar?
I asked for backup, and my partner and I went into the bar, and yes.
You looked around the bar?
Both of us did, yes.
You didn't see Mr. Donnelly at the bar?
No, neither of us saw Mr. Donnelly there.
You didn't locate any guns at the bar?
No.
And I take it you'd been to that bar before?
A few times.
From your knowledge, nothing appeared out of the ordinary that night in the bar?
Well, it was busy. It's a Friday night. There was a lot of people, but nothing that concerned me.
And as is usual, the bar is fairly dark. The lighting is not great?
Well, it's subdued lighting for our atmosphere.
And Officer Standard, you testified that at approximately 10:05 p.m. you attended 1022 Tampain Street?
Yes, that's correct.
That's the residence of Mr. Donnelly's surety?
That's correct.
Mr. Donnelly is on a condition to reside there?
He is still on a condition to reside there, that's correct. That was pursuant to the bail materials, the information from his bail that I received.
And that bail is from September 18th of 2019?
That's right. He was given bail on a charge of domestic assault against Ms. Jones.
He's only been on that condition since September 18th, 2019.
That's true.
Prior to that date, Mr. Donnelly had not resided at that address.
At the Tampain address?
That's correct.
My understanding from my perfunctory review of the materials about that domestic assault from September, my understanding is that he and Ms. Jones were living together at a different address.
That's at 460 Smallwood Drive?
Yes, that's correct.
And so at approximately 10:05 p.m., you arrest Mr. Donnelly?
Let's see. Yes, that's correct. Yes.
You didn't have a warrant at the time?
I didn't have a warrant for his arrest. I was operating on reasonable and probable grounds provided by Ms. Jones about her allegations that he yelled at her in the bar, threatened her, and then pointed a gun at her.
You didn't have a Feeney warrant to enter the residence?
Not yet, no.
Mr. Donnelly was cooperative with the police when you attended?
That's true.
He was searched incident to arrest?
Of course.
You didn't find any firearms on him?
Not in his person.
No ammunition was found on him?
Again, not on his person.
There was no one else at the residence at this time?
At that point, we didn't know that upon arrest, but very shortly after that, we realized that was true.
You testified that a search was done at 1022 Tampain Street.
Yes, of course. Looking for the gun.
Mr. Donnelly was not present when the search began?
No. After his arrest, he was transported by a colleague to 33 Division for processing.
And at that point, after Mr. Donnelly is arrested, there's no one else at the residence, only the police?
No other civilians were present. We, as I say, shortly after his arrest and transport, we realized that, yes, no one else was present. No other civilians were present on scene.
And the search of the residence begins at approximately 10:40 p.m.?
That's correct.
You said there was a search warrant?
There was. We ordered a tele-warrant. I called my colleagues at 33 Division to have a tele-warrant initiated. I was the affiant on the information to obtain.
And that search warrant was not authorized until about 11:42 p.m.
So that's true. We became very concerned about the fact that there seemed to be no a gun in play, and there was no one on the bail registered living there who had a firearms license, and so we were very concerned, and so entered the residence to try and secure that gun on exigent circumstances.
But at the time, officer, no one else is at the residence, no civilians.
That's true.
And Ms. Jones was already at the police station making a statement.
That's true. She'd been transported to make her videotape statement.
And Mr. Donnelly's already in custody.
Yes, that's true.
Now, officer, 1022 Tampain Street is a townhouse.
That's right.
It's 2 floors.
Yes, I believe so.
4 bedrooms.
I recall 4 beds in different rooms. Yes, that sounds right.
Finished basement.
Sure. Yes.
No separate entrance for that basement?
Oh, goodness. I wasn't really looking for such a thing, but I don't recall one.
Are you aware of the number of people who reside there?
The only information that we have is pursuant to Mr. Donnelly's bail, which indicates that his surety lived there at that address and he was required to live with her there.
And his surety is Ms. Williamson?
That's my understanding from the bail, yes.
You haven't spoken to Ms. Williamson?
No, I haven't.
You haven't spoken to Ms. Williamson on October 11th?
No.
Or since then?
No, never spoken to him.
And during your search, you were able to access all the rooms?
I was. We were, I should say. Of course, there was a number of us.
The rooms weren't locked when you conducted your search?
No, we didn't have to breach any doors.
You simply had to open the doors,
the
bedroom
right.
doors.
That's right. We just easy to access every part of that house.
And your evidence is that the gun is found in one of the bedrooms on the main floor?
Correct.
In a closet?
That's right.
In a gun safe?
That's true.
The gun was not visible when you entered the room?
That's true.
The bedroom door was closed?
As I recall, yes.
The closet door was closed?
Similarly, I remember having to, open the door, whether it was latched or not.
The gun safe was not visible when you opened the bedroom door?
No, that's true.
And when, in fact, you opened the gun safe, there's no ID found in the gun safe?
The only thing in the gun safe was the weapons, the gun.
There's no ID found in the closet?
I wasn't looking for ID. I was looking for a gun under exigent circumstances. But that's true.
You didn't locate any ID?
No. Again, I wasn't looking for it, but no, we didn't find any ID.
You didn't find any ID in the bedroom?
No. Again, we didn't look for it, but that's true.
And in fact, you don't know who occupies the bedroom where the gun was found?
I don't know if anyone does at all.
You don't know which of the bedrooms Mr. Donnelly was sleeping in since his release on bail, September 18th? That's true. And you haven't spoken to Ms. Williamson, you said?
Again, no, never spoken to her.
You, in fact, don't know if anyone else lives in the home.
Our information is limited to what's on the bail at this point, but on his recognizance.
But other people could be living in that house.
Anything's possible. I just have no information.
There's certainly other bedrooms in the home.
Again, yes.
And if other people are, if there are in fact other people living there, they could have firearm licenses.
Well, they could, but they might not. We don't know. We have no information.
So you, after you found the gun, you seized it.
Of course. I removed the safe from the closet. I removed the firearm from the safe. I unloaded it, made it safe, and then transported it in my trunk of my vehicle to the division where it was processed.
And you stored it in a police locker?
Of course.
To your knowledge, the gun was never tested for fingerprints?
Not to my knowledge.
It was never tested for DNA?
I have not to my knowledge.
Now, on September the 15th, I know you were not the investigating officer, but you're aware of that investigation.
You're referring to the original arrest for assault that Mr. Donnelly was placed on bail for with conditions to have no contact with his ex?
The original arrest on September 15th?
Yes, I'm aware of that.
And on that date, Ms. Jones did not call the police.
My perfunctory review of the materials for that arrest is that, yes, a neighbor called, not Ms. Jones.
Now, Ms. Jones had provided a few statements to police since that date on September the 15th.
Yes, she made her initial, again, my understanding is she made her initial statement on the 15th, and then with me on scene on October 11th at the Grumpy Joe's bar, and then her videotaped statement that night. Yeah, there was a few statements.
And in fact, she spoke to the police on October the 12th, just 2 days ago as well.
That's true.
And you're aware of that?
Yes.
And on October the 12th, Ms. Jones told the police she wished to recant her statement.
That's true.
That all Mr. Donnelly did on September 15th was grab her arms.
Well, what she said is that he grabbed her by the arms and she had to use so much force to extricate herself, she fell on the floor.
She said she believed he had no intention of hurting her that day.
That's true.
She said she pulled away from him.
Well, yes, she said she had to pull away so hard that she fell on the floor, though.
But that's how she landed on the floor.
That's what, yes.
And she never said that Mr. Donnelly struck her on September 15th.
That's true.
She never said Mr. Donnelly grabbed her by the hair.
That's true.
She never said Mr. Donnelly pulled her to the floor.
That's true, yes.
And on October the 12th, after Mr. Donnelly's arrest, Ms. Jones told the police that she wanted Mr. Donnelly's bail conditions changed.
Yes.
That she wanted him to move back home.
Yes, that's true.
And that she has no safety concerns.
That's true.
Thank you, Officer Sand. Those are my questions. All right. So as you can see, a lot of what the officer testified to is information that was not originally in the synopsis, but it's information that you would have obtained from speaking to the officer before the bail hearing started. You would have received either a summary or some sorts of notes, monitor notes perhaps from the interview with the complainant on October the 12th, so you would have known that she recanted the original statement from September the 15th, and as well that you would have had some more information about the search of the residence and about the timing of the warrant. So this is all information that you would have thought about in reading the synopsis and thinking of the issues and the questions you would have asked the officer in charge. So we'll probably just open it up for some questions. I have about 10 minutes left. Please feel free to ask anything if you have anything that surprised you, if you have any specific concerns about cross-examinations, anything that comes to mind, please let us know.
And I'll remind you to unmute your phone, please press *6. You can also enter your questions in the chat.
And if you feel that we missed something, we're happy to address perhaps why we didn't or whether we messed up.
We have a few people typing in questions, which is fantastic, so we'll just wait for those to show up in the chat.
While we're waiting, I do want to thank Georgia Coolis for all her help with this presentation as well. I've taken up quite a bit of her time in speaking to her about some of the points, the presentation, and the cross. So thank you, Georgia.
Okay, Joy, you are the first one to get a question in. So Joy has asked, how do you ask an officer questions without putting them on notice / giving them an opportunity to come up with better answers?
Sometimes you can't. The reality is that the best defense weapon against that is to ask exactly what the officer put in their notes, so that if they try and deviate from it because they've been given some sort of warning, then you simply put to them, on this date, you type this in your notes. On this date, this is what the person said on, in their videotape. That's really I think, the best you can do.
And what we discussed during the presentation is that you don't want to have headlines. You may have headlines in your own questions, but you don't want to say, okay, officer, now I'm going to take you to the time when you attended the residence and started the search. So just ask them about the search. Don't give them that introduction so they know where you're going.
And if they're going off on a tangent, it's sometimes, if they're going off on a tangent and they're not answering your question, say so. That wasn't my question. This is my question.
So I did see that several people were typing. You do need to press enter for your message to come up. Okay, so Joy has a follow-up question, and what is the benefit to having an officer testify versus pointing these issues out in submissions?
So that can be a tricky one, because it's sometimes, when you look at allegations, if you think that there are so many gaps in the Crown's case as it is, that you don't want to have an officer attend and fill in those gaps, then stay away from asking for the officer to attend. But it's really a judgment call, I think, every time. If you have enough there to poke holes, just let it be. Don't ask the officer questions. If you don't, or sometimes it depends on the Crown as well. If it's a Crown who is not giving you information when you're asking questions, and you know, for example, that there are issues, but the Crown is not prepared to admit that there are issues, then you may want to ask the officer those questions. But also keep in mind that if the officer attends, you will have the opportunity to speak to them ahead of time, so that you don't have that element of surprise. You don't want to be surprised during the cross-examination. You will ask the officer questions about that ahead of time, and you'll know what you're getting.
If the synopsis obviously has a lot of holes in it, you probably want to take advantage of that and simply operate on the synopsis. If you're getting information from another source, your client, another witness, that is not in the synopsis, then you might consider calling that officer, talking to them, physically calling them on the telephone or communicating with them to find out whether they can confirm that good exculpatory evidence. If they can, wonderful, bring them in. And if they can't, if they're arguing with it, then you've got a hard decision to make.
Omar Sherman also had a question. Admissibility of police occurrence reports as evidence against the client and the proposed sureties.
Those exist. I'm not sure I understand that there's a question there. I'm sorry.
I think the question is about whether the Crown can rely on them at the bail hearing, and often we object to those. Often these occurrence reports are uncharged conduct, and we would object on the basis that it's either not credible and trustworthy, or it's irrelevant, specifically when it comes to sureties, but also often when it comes to our clients. Sometimes it's also on the basis that the probative value is outweighed by the prejudice. And so most often we would object to the admissibility of those occurrence reports. Now, a lot of justices of the peace still allow them in. They still determine that they, or rule rather, that they are credible and trustworthy evidence, but say that they will give very limited weight to that evidence. So all you can do is object, really, and it's up to the judge or justice of the peace whether or not they'll be admitted. But then if they are admitted, the weight that should be given to them is really close to zero. One thing that we just want everyone to get from this presentation really is that don't be concerned because we haven't done a lot of these OIC hearings in the past as duty counsel. There have been a lot more private lawyers coming to cross-examine officers in more serious matters. Don't be afraid of the officer. The officers can be valuable sources of information, and it's pretty fun a lot of the time to cross-examine them. So just as long as you plan your cross-examination, as long as you know what you want to get from the officer, your examination may be very short, but it's not something you have to be worried about. Just like the synopsis where you have questions, you might have questions for the officer, or you might not have questions for the officer. And if it so happens that the case is bad as is, you may not even ask any questions. So that's really a judgment call. Every case is different. More questions being typed.
So Mary McCormick has asked, is there any remedy to avoid a lengthy delay if we are advised the officer in charge is on holidays and not available for 1 to 2 weeks?
So often what will happen is that another officer will come in. It's not necessarily the investigating officer. Any other officer can come in their stead. And if the Crown is saying to you, we can't have a hearing in 2 weeks because this officer is not available, you can certainly say, well, I'm sure one of the officers is available, and so I'm not agreeing to this delay. It's a Crown delay, and this is my client's right to reasonable bail that's being affected, their charter right. So have a Crown contact the officer or their designate to see if another officer can attend.
And remember, the only reason a synopsis is read in at a show cause or bail hearing of any kind is because the defense agrees to it. So all you have to say is you need to call evidence for this case if you really believe that you need an officer to give evidence and be cross-examined.
It looks like we have another question coming in. Okay, Omar, is it a good idea to ask for further disclosure? For example, in this simulation, there may have been video evidence from the coffee shop.
In this case, I would say no. For two reasons, well, or maybe more reasons than that, but the first two reasons that come to mind. A, if there is video, if it shows your client with the complainant, that's evidence of a breach, and at this point, other than her saying he was there, there's no other evidence, and clearly her credibility is pretty shaky when she has recanted, and you have evidence of that from the officer. And secondly, even if there is surveillance video, it's very unlikely to show what that object was, if it was in fact pointed. It's a dark bar, a lot of people, so you probably won't get any helpful evidence from the video, but you might get some evidence that's damaging to your client.
That particular example isn't the best example. There's always going to be circumstances when your client tells you that, oh, if you just get the video, it'll show the truth. The problem is, of course, as soon as you request the video through the Crown's office, then they have it to use at the bail hearing too. So make sure your client knows that before you start requesting things.
And also keep in mind that this will, if you ask for a video and it's not available, not in this case, but in another case when you think it might be helpful, you have to weigh the benefit of getting that video against the damage to your client from longer delay in having a bail hearing. They have to sit in custody until that's available if you want that disclosure.
And we have one last question. We are just at 2 now, so hopefully we can get a quick answer to a short question, and then we'll wrap it up. Could you have asked if anyone else at the bar was interviewed, i.e., would no one have noticed a gun and someone running out of the bar?
Yes, we certainly could have. One reason we didn't, or we decided not to, is that there may have been some people who were interviewed, and so if that evidence didn't come out in chief, then I wouldn't want to introduce evidence of other witnesses to a breach. And the second part of that question, no one noticed a gun. So there were some questions in our cross about that there were a lot of people in the bar, nothing seemed out of the ordinary, and you could put it in your submissions that if there in fact was a gun, or if she ran out saying there was a gun, then the bar wouldn't have been a very happy place just a few minutes after when the officer goes in, or the officer and his partner go in.
And this is a really good example of asking questions that seem innocuous that you can later use in your final submissions. No one noticed anything untoward. Okay. Or the police officers didn't when they were in there, more specifically.
Thank you very much. Thank you, Gina and Stephanie, and thank you to everyone for attending this session. I just want to point out to you, in the emails I've sent and also posted on the page on the DC Think Tank, there is a workbook for the series. The version that's there right now includes all of the content from the slides. I will also be posting the slides. And then that workbook gives you a place, if you want to spend some time at a team meeting talking with your colleagues, I'd encourage you to talk a little bit about what this means at a local level, any of the local issues you may have had, or questions about how you want to apply this, and information from your manager. So feel free to use that. For the next 2 upcoming pieces, it'll also be there. You can use it to take down notes on any big ideas you come up with, and it's sort of a workbook for you to take advantage of. The second webinar in the series about arguing tertiary grounds is scheduled for Wednesday, January 8th. Please keep an eye on your email for the login information. I will be sending the information early to remind people who didn't attend today to review the case. We'll be using the same case for the next 2 webinars, but there may be additional reference material that we post before the next session. So again, have a look at the email and see if there's anything attached. When this meeting ends, an evaluation will open. Please take a few minutes to provide your feedback. And we're especially interested in any suggestions you may have for the future webinars in this series and other topics around bail where you'd like to have practical advocacy, especially demonstrated in this way. As I mentioned before, for CPD purposes, we need to maintain a record of who attended in case you're audited. If you've been participating as a group, please send me, either through my personal address or General Learning, a list of the people who participated. And I'd like to thank you very much, and hopefully we will see you again on January 8th.
Karen, can I just say one thing before we leave? If anyone is worried, if you have a cross-examination of an officer coming up and you're worried and you want to talk about some of the questions you might want to ask, feel free to reach out to us. Our emails are available, I guess, in the materials, or if Karen can send our emails out, we'll be happy to speak to you to go over the synopsis and anything else that you might have to prepare.
Thank you, everyone. We'll leave it running in case people want to add comments. We're getting lots of positive feedback for Dina and Stephanie, so I'll leave it running, but that wraps it up. Thank you.
Thank you.
Thank you.